Let's get going. Senate Committee on Criminal Justice come to order. The clerk will please call the roll.
Chair Flores,
Present.
Vice Chair Parker, Senator Hinojosa,
Present.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu.
A quorum is not established, and as members come in, and we'll log them in and establish the quorum. Today's agenda represents the fourth month of work by this committee to improve public safety, to lock up the criminals who are violating our laws and victimizing our communities, and to make Texas a safer place for us to live and work. Senate bills on a variety of issues, from stopping attacks by dangerous dogs to a property owner's liability to defend themselves and their property, to enforcement of human trafficking laws, to tougher penalties for dangerous and reckless driving and large-scale illegal dumping are on our list. So are House bills that enhance penalties for endangering a child, elderly person, or disabled person, sex offender registration, requirements for those who sexually groom children, and new rules for prison workers concerning de-escalation and crisis intervention inside our Texas prisons to prevent injuries or deaths. Members, this continues our work to make Texas a safer place. It is the intent of the chair to lay out the bills one at a time and then vote them out as we have a quorum available. So if you intend to provide verbal testimony and would like to register a position on one or more bills, please register at one of the kiosks located behind the committee hearing room. So members, any statement you wish to make before we proceed? Well, we'll proceed. We have a pretty full agenda, so I'm glad to see we're starting to get House bills and get moving on as we head towards the final weeks of our session. So we'll start with Senator Zaffirini.
Right here beside me.
Thank you.
Which one?
Boy, lots of senators
When's that
here
from?
today.
1848, right there.
1, 2, 3, 4, 5, 6.
Chair lays out Senate Bill 1848 and recognizes Senator Zaffirini to explain the bill.
Thank you, Mr. Chairman. Mr. Chairman and members, Senate Bill 1848 relates to the disclosure of confidential juvenile records to a managed assigned counsel program. It is a companion to House Bill 4885 by Representative Joe Moody, which is already in calendar, so we'd like to leave this bill pending and then exchange this bill for the House bill. Members, most information about juvenile cases is confidential as a matter of law. The Family Code provides narrowly tailored lists of approved persons who may access information in juvenile cases, including prosecutors, a child's parents, and a child's attorneys. The list should include managed assigned counsel, or MAC, programs that ensure qualified attorneys are appointed to represent indigent defendants, including juveniles. Senate Bill 1848 would ensure juvenile defendants with indigent parents have their rights to counsel met by authorizing MACs to access sensitive but highly relevant information regarding their lives and prior experiences with the criminal justice system. Generally, then, Senate Bill 1848 would add MAC programs appointing counsel for juveniles to the narrowly tailored list approved to access juvenile case information. And that is all the bill does, Mr. Chairman.
Thank you. Members, any questions? Show Senator King is present and a quorum is established. Any questions for Senator Zaffirini? With that, Chair now opens up for invited testimony. There's no one registered for invited testimony. Chair now closes invited testimony. Chair now opens public testimony on Senate Bill 1848. The Chair recognizes Scott Ehlers. Scott Ehlers. Good morning. If you state your name, who you represent, your position on the bill, and you have 2 minutes.
Great. Thank you, Chair Flores, members. I'm Scott Ehlers. I'm the Executive Director of the Texas Indigent Defense Commission. This proposal went through TIDC's legislative work group process and was approved by our Board of Directors. It was brought to us by the Bexar County Managed Assigned Counsel Program. MACs have been authorized to oversee juvenile cases since their inception in statute in Texas in 2011. But Bexar County is the first county that actually wants to oversee juveniles through those cases through the Managed Assigned Counsel program. So Bexar County brought us this proposal, and basically it's just needed to ensure that they can appoint counsel properly to attorneys who are overseeing those cases. And really, that's the narrow purpose of the bill.
Any questions, members? Thank you very much for your testimony.
All right, thank you.
Chair sees no one else registered for public testimony. Is anyone here present wishes to testify on, for, or against Senate Bill 1848? Hearing none, public testimony is closed, and we will leave the bill pending.
Thank you, Mr. Chairman and members.
Chair lays out Senate Bill 1790 and recognizes Senator Campbell to explain the bill.
Thank you, Mr. Chairman and members. This bill changes the Comal Juvenile Board from membership of 9 down to 7. Thank you.
Members, any questions? I like those type of bills. So invited testimony, Senate Bill 1790 is now open. There's no one here for invited testimony. Invited testimony is now closed. Chair now opens for public testimony. There's no one registered to testify publicly from Senate Bill 1790. Public testimony is now closed. And we will hold this bill pending, and we will vote the bills out as we get. You did good.
Thank you very much. I must admit, my district attorney, Comal County, is here. The Honorable Jennifer Tharp, very happy to have her, had to do a good job because she's sitting here.
Well, thank you.
Thank you. Thank you, Mr. Chairman. Thank you, members.
As a matter of pending business, the chair lays out Senate Bill 2611 by Senator West.
Thank you very much, Mr. Chairman. I have a committee substitute that I need to send up.
Chair sends up committee substitute for Senate Bill 2611. Is there any objection to the adoption of the committee substitute for Senate Bill 2611? Hearing none, so ordered. Recognize Senator West to explain the difference between the committee substitute and bill as filed.
The substitute creates a specific crimes and reporting for fraud related to real property. At present, theft of real property is treated no different than the theft of a purse. Under this bill, some language from the theft and fraud statutes have been moved into specific new criminal codes for real property theft and real property fraud. This reinforces that these are crimes against real property owners, buyers, banks, lenders on real property, and the title companies insuring titles. Let me just make sure you remember what this particular bill is. We create a new 10-year statute of limitation period for real property theft, and a judgment of conviction must include the street address or legal description of the real property. This frankly helps those persons that moved in a civil suit to clear title, and also requires an order of restitution.
Members, any questions?
It's a great bill.
I think
Senator Hinojosa.
thank you, Chairman. It's a pending bill, right?
It is.
Yes.
Okay,
Yeah.
thank you.
Well, we're going to hold the bill pending for pending the vote. Thank you. Go. Chair lays out Senate Bill 1730 and recognizes Senator Hall to explain the bill.
Thank you, Mr. Chairman. Members, this bill is really the civil companion to our doctrine philosophy that Texas adopted a few years back. In Texas, we have a castle doctrine, which is a legal principle of princely use of force, including deadly force, affirming the right to defend oneself within one's own property, providing a defense against criminal charges. However, under current Texas law, individuals may file civil lawsuits seeking damage for personal injury or death resulting from the use of force or deadly force, even in cases where the defendant's actions have already been deemed lawful in criminal proceedings. For example, if a homeowner uses deadly force against an intruder and a grand jury declines to indict the homeowner, the injured party or their family could still pursue a civil suit against the homeowner. This creates a substantial financial and emotional burden for defendants as they must defend themselves against potentially meritless claims, often at great personal expense, despite having been cleared of criminal wrongdoings. Additionally, the law provides no deterrent for plaintiffs filing these lawsuits, as they are not required to cover the legal costs of attorney's fees incurred by the defendant, even if the court ultimately finds their claim invalid. This legal gap leaves defendants vulnerable to excessive litigation and financial strain, undetermined projections of the criminal justice system. What SB 1730 would do is prohibit claimants from recovering damages for personal injury or death resulting from a defendant's use of force or deadly force if a grand jury issues a no bill of indictment for criminal charges related to the act, the court dismisses criminal charges related to the act, or the defendant is acquitted of criminal charges related to the act, and the bill would hold claimants liable for the defendant's court costs and reasonable attorney's fees. Members, I ask for your support for this to close this gap and protect citizens' right to self-defense.
Members, any questions? Senator Hinojosa?
Thank you, Mr. Chairman. You know, Texas has the castle doctrine, and I supported that and still do. I guess my question is more focused on this doesn't apply to police officers who are doing their duty out and about.
No, this is aimed at individuals in their home.
Okay, I just want to make sure we're clear on that because we have a different structure of statutes and laws that apply to police officers,
Yes.
self-defense and deadly force and what have you. So this is just focused on anybody. It could even be a police officer who happens to be home that night and asleep, and burglar breaks into the house and he catches that, and burglar has a gun and has to defend himself and shoots him. Those are the type of cases you're talking about.
That is correct. That's on the civil side. As you all know, we've got two justice systems. We have the criminal and we have the civil. And we find that people are well protected on the criminal side, recognizing your right to defend yourself, particularly in your home, the castle doctrine. But it left open civil suits. And so we find that families or people follow through. Well, you know, they didn't need to do this, so they file. And even if they don't win, the amount of money that the defendant has to pay just to defend themselves destroys them. And so this just brings into balance that you are, in the legal system, that you're justified in defending yourself in your home from the legal side and from the civil side.
So if a grand jury finds or does not indict the individual, then it prohibits a civil lawsuit. If the grand jury indicts the individual, can you still bring a lawsuit?
That opens it up. That changes.
Even though the defendant could go to trial and still be found not guilty?
If they're found not guilty, no. If they're found ultimately not guilty, then no.
Okay. Thank you for answering my questions.
Members, any further questions? The chair now opens up for invited testimony on Senate Bill 1730. The chair calls Kyle Carruth. Kyle Carruth. Good morning. If you state your name, who you represent,
Yes.
position on the bill, and you can begin your testimony.
Thank you, Senators, and good morning. My name is Kyle Carruth, and I am here representing myself, and I am for Senate Bill 1730. I am one of those individuals that this actually occurred to. I was involved in a self-defense situation at my home on my farm with a man who explicitly told me that he was going to take my firearm from me and effing kill me, and then tried to do so. And inside of that, I defended myself. I was never arrested. I was never charged. The Attorney General convened a special grand jury that reviewed testimony and evidence for over 3 days in this special grand jury, and ultimately, all members of that special grand jury returned a no bill unanimously on all potential charges. Despite that, I was sued in civil court for $51 million for wrongful death. A man who was clearly trespassing, who had been trespassed already, and had blatantly and openly told me that he was going to kill me and tried to do so. And I still had a $51 million civil lawsuit filed against me. Inside of that, as I'm sure y'all are aware, the civil process takes potentially years to get through and clogs up the system substantially, but also subjects law-abiding citizens like myself to unnecessary burdens that did cost me over $500,000 in legal fees alone. Inside of this, it was a 3-year process. Inside of that process, in order to maintain the integrity of venue, I couldn't speak about any of this. And as such, the family of the individual had over 3 years of putting out a story and a false narrative about me that I was a murderer and a cheater and a liar, despite having no evidence to that whatsoever. I was subjected to a system that is meant to help people, but instead was used in lawfare to punitively subject me to harm. I don't see this as a issue that is either right or left, but instead crosses the boundaries of the aisle, because we are all given the right to self-defense and the right to life by God and God alone, and we all have that right. So I urge you, of course, this bill would not help me. My situation is over and finished, but I'm here to make sure that this doesn't happen to other law-abiding Texans, no matter the situation and the individual. And I urge you to pass this bill immediately. Thank you.
Senator Hinojosa.
As I listen to your testimony, I do agree it can be a burden when you're found not guilty or no bill.
Yes, sir.
But I couldn't help but remember the O.J. Simpson case in California.
Yes, sir.
If California had the same statute, that means that they could not have sued O.J. Simpson.
Yes, sir.
Am I getting that correct?
So we do have some legal experts that can speak more directly to that, but what I can say is that my understanding of the O.J. Simpson trial is that it is one of those outlier situations, and while outlier situations are important, without a doubt, we're here to protect the majority of Texans, and that's what I hope that you'll see inside of this.
If the glove doesn't fit, you cannot convict. That. Thank you
Yes,
for your
sir.
testimony.
Thank
Senator
you.
King.
Thank you. Thanks for being here.
Yes, sir.
So, I just want to make sure I understood the facts. So, local district attorney did not prosecute the case, did not convene a grand jury,
Correct.
but the attorney general's office convened a grand jury. How did that happen?
Correct. So at the time, I was married to a state district judge, and the family of the man alleged that there was political corruption associated with it. And as such, our local DA recused themselves and allowed the top law enforcement official in the state to come and investigate for a non-bias look at the situation.
Okay. I was trying to think where their jurisdiction was to do that, but anyway, thank you very much.
Yes, sir. Thank you, Senator.
Senator Hinojosa.
I'm sure they had it. I just
Make a
don't.
request for the Texas Rangers to come in and investigate and ask the Attorney General. The DA can ask the Attorney General to step in
That's correct.
at the invitation of the district attorney.
Okay. I knew they could do that in public integrity unit issues, but I didn't know they could just do it in just a straight up homicide case.
And Senator, and this is a little outside of my purview. I believe that there is someone from the Attorney General's office here today. Perhaps they can
I'm
comment.
sure they had jurisdiction. I'm just confused where. Thank you.
So my understanding of the special grand jury is that those are one of the reserved purposes for a special grand jury is in fact political corruption. And so I think that the situation was so plain and clear cut that the only way that it could be anything other than self-defense is if in fact it was political corruption, and it was not.
There have been previous cases, if I may, Mr. Chairman, where, for example, in Webb County years ago, there were allegations against corruption against the mayor, and there was a special grand jury established at the invitation of the district attorney to bring in the Attorney General's office. I think at that time it was John Hill who was the Attorney General, so they do have that authority, I think, at the invitation of the district attorney.
Thank you, Senator.
Thank you, Senator. Senator Hagenbu.
Thank you, Mr. Chairman. Just wanted to say thank you for coming and testifying today.
Yes,
your case is very applicable, so it's a good one for us to hear. And I'm glad that that our criminal law protected you in this case. I'm glad you were able to protect yourself in your home. And I think it's a good bill to help us with the civil side. So thank you for just testifying. Appreciate it.
Thank you, Senator. Again, I just hope that no other Texan is subjected to what I've been put through over the past 3.5 years.
Okay. So I was looking at Senator Hancock that your light was on, so. Okay. Any other questions? Thank you. Thank you very much for your testimony.
Thank you, Mr. Chairman. Thank you,
for being
Senators.
here. Chair sees no one else registered for invited testimony. Invited testimony is now closed. Chair now opens up for public testimony. Chair recognizes Richard Hayes. Richard Hayes. Good morning. Your name, who you represent, your position on the bill. You have 2 minutes, sir.
Yes, my name is Richard Hayes. I'm an attorney and partner with the law firm of Walker & Taylor. I'm testifying on behalf of Gun Owners of America and myself in favor of SB 1730. So current law, what we have under Chapter 83 of the Civil Practice and Remedies Code is there is immunity from damages if the person's conduct is justified under Chapter 9. That's where all of our self-defense laws live. What we find, though, is that, that's an issue of fact for a jury or judge. And, this leads to protracted litigation. And I've told this to my clients, and we've seen a huge uptick in this of self-defenders getting sued, I'd say probably fivefold in the past 2 years, and we can talk about that if you'd like. But I think it's because and I tell my clients this, the punishment is the process, and the cost of litigation is extremely high. And I think this bill is very important because it creates this clear break in responsibility. We have those conditions, and I think it would lead to a quicker resolution, less cost of litigation. But ultimately, what this comes down to, if folks don't have the ability to defend themselves because they're going to get wiped out on the civil side, self-defense doesn't mean anything in the state of Texas. The system is being abused right now. I think the plaintiff's lobby, personal injury lobby, those constituencies, they've kind of figured out how to game these self-defense cases, invoke insurance, and are just looking for a quick payday. And so really, we want to create good incentives. Self-defense is good policy. And so for that reason, I would urge y'all's support for 1730.
Thank you for your testimony. Any questions, members? Thank you very much, Mr. Hayes. The chair sees no one else registered to testify publicly. Is there anyone else that wishes to testify on, for, or against Senate Bill 1730? Hearing none, public testimony is closed. We'll leave the bill pending for the vote. Chair lays out House Bill 166 and recognizes Senate sponsor, Senator Hancock, explain the bill.
Thank you, Mr. Chairman. House Bill 166 is the companion to Senate Bill 1234, which you've heard a couple of weeks ago. As strangely as it sounds, current statute provides that someone who places a child, elderly individual, or a disabled individual in imminent danger of death, bodily injury, or physical or mental impairment by exposure to methamphetamine, not fentanyl, just methamphetamine, through any of the several different ways, then such an offense is a state jail felony. House Bill 166 brings in the penalty group 1B to that existing statute. Penalty Group 1B is fentanyl and other related opiates. So we're just simply bringing fentanyl and related opiates into the same code as where methamphetamine is currently. So that's what it does.
Members, are there any questions of Senator Hancock? Hearing none. Invited testimony is now open. I see no one registered for invited testimony on House Bill 166. Invited testimony is now closed. The chair now opens up for public testimony. The chair sees no one registered to speak publicly on House Bill 166. Is there anyone there present that wishes to testify on, for, or against House Bill 166? Hearing none, public testimony is closed, and we'll leave the bill pending. Chair lays out House Bill 2000 and recognizes Senate sponsor, Senator Nichols.
Thank you, Mr. Chairman and members. Today I bring forward House Bill 2000. This bill carries the weight of the devastating tragedy in East Texas. This legislation was filed in response to the heartbreaking loss of 11-year-old Audrey Cunningham, a young girl from Polk County whose life was taken far too soon. In February of last year, Audrey was abducted and murdered. Her disappearance shook the community, and the details that emerged through the investigation were very deeply disturbing. It garnered national attention and sparked widespread grief in her hometown. The man responsible, Don McDougal, had been staying with Audrey's grandparents, who were trying to help him get back on his feet. They had no idea he had a criminal history involving children. In 2007, McDougal was accused of indecency with a child, but due to lack of evidence, he pleaded to a lesser charge, enticing a child, which did not require him to register as a sex offender. The gap in the law left the family unaware of the risks they were bringing into their own home. House Bill 2000 is known as Audrey's Bill, seeks to close the gap by requiring individuals convicted of the offense of child grooming to register as sex offenders. The offense was added to the penal code last session and addresses conduct intended to prepare or entice a minor for sexual abuse. While it's a felony, it currently does not trigger sexual offender registration. This bill changes that, ensuring that the public has access to information that can help prevent future tragedies. I want to thank Representative Ashby for filing this bill in the House and for working with Audrey's family to ensure her memory is honored. This bill is necessary as a step to ensure our registry reflects the realities of predatory behavior and helps prevent future tragedies. Thank you, members.
Thank you, Senator. Please show Vice Chairman Parker is present. Any questions of Senator Nichols, members? If not, the chair now opens it for invited testimony. The chair sees no one registered for invited testimony. Invited testimony is now closed. Chair now opens up for public testimony. Chair sees no one there. The chair recognizes Andy Kahn. Good morning.
Morning.
You already know the drill, but for the record, your name, who you represent, your position on the bill. You have 2 minutes, sir.
My name's Andy Kahn. Excuse me, I'm the Director of Victim Services for Crime Stoppers of Houston, and I'm here in support of what's now being called Audrey's Law. The gist for Audrey's Law began a little over a year ago. And I first want to preface that her family would like to thank Senator Nichols for being the Senate sponsor for this, and of course House Representative Ashby for shepherding this throughout the House. They send their regrets. They cannot be here today. They can just for work obligations that are keeping them out of the state. So they asked me if I would represent Audrey's family, which I'm proud to be able to do. A little over a year ago, in February, 10 days after Audrey Cunningham's, 10 days after her 11th birthday, she was kidnapped, sexually assaulted, murdered, and tied to a large rock before being dumped into the Trinity River. She was eventually found after a massive national search. Suspect, who was later then charged and pled guilty, had a lengthy criminal history. The family, due to their faith, took him in and allowed him to live on their premises, hoping that his past would be the past. They checked his sex offender registry and found nothing there. What they didn't know was that at one time, McDougal, the offender, was charged with indecency with a child that was pled down to enticing a child. And by accepting that plea, it meant he didn't have to register as a sex offender. That loophole potentially could have cost Audrey Cunningham her life.
Go ahead and finish.
Thank you. They found out later on about that, and they reached out to me, and thus the gist and the genesis of what's now called Audrey's Law has now become, and here we are today. Sex offender registry is one of the only tools that parents and grandparents have to protect innocent little angels like Audrey from predators. What we're asking you to do is kind of close this loophole. You know, there's glitches in the system. We find a glitch in the system. Let's seek the remedies, and let's close it up here today. I've been doing this a long time, and I've seen a lot of laws that unfortunately are named after dead kids in the state of Texas. You have Emma's Law, named after 4-year-old Emma Thompson. Randall Dale Harvey Law, which was named after a 15-year-old boy that was killed by a serial killer. David's Law, cyberbullying. Jessica's Law, child abuse, child sex abuse. Carrie's Law, and finally, as we all know, Amber's Law, which is Amber Hagerman. And as I stated in the House, I get tired of naming laws after dead kids, but this is where we are today. I told the family that Audrey Cunningham would be a catalyst for change. And that's what has to happen here today. Can't go back and change what happened to 11-year-old Audrey Cunningham, but we can make it better for others to come along, and hopefully there will not be any more 11-year-old Audrey Cunninghams. So I'm asking you to please vote the bill out, get it to the Senate, get it to the governor, and let's protect kids in the state of Texas. Thank you.
Thank you. Members, any questions? Thank you very much for being here. Senator Parker.
Thank you, Mr. Chairman. Thank you for your testimony. Appreciate you being here, and please give the family our very best regards, and tell them that their baby girl's memory will not be forgotten, and we'll pass this legislation and get it done.
No, and I'm sure
Senator
Audrey
Nichols is a great
Cunningham.
piece of legislation
yeah,
here.
Right now, she's probably looking down from heaven going, thank you guys. You know, my memory is not going to be in vain, and my legacy will last for eternity. So
Amen.
Thanks for recognizing that.
Amen. Thank you for being here. Thanks for all you do, sir. Thank you.
Thank you. The chair sees no one else registered to testify publicly on House Bill 2000. Is there anyone here present which to testify on, for, or against House Bill 2000? Hearing none, public testimony is closed, and we'll pen the bill pending voting. Chair lays out Senate Bill 2794 and recognizes Senator Paxton to explain the bill.
Thank you, Mr. Chairman, and thank you, members. Currently, the offense of child custody interference only penalizes the parent without custody and does not apply to or penalize the custodial parent for the same actions. Senate Bill 2794 removes the title non-custodial when describing the parent who commits the offense of interfering with the other parent's court-ordered time with the child. And it likewise removes the title of custodial in describing the parent the child is being convinced to leave. In removing these specification, it allows the offense of child custody interference to apply regardless of which parent is interfering with the other parent's court-ordered parenting time. In addition, since the enforcement of these laws has been inconsistent and there's currently no increased penalty to deter repeat offenders, Senate Bill 2794 establishes a 3 strikes policy for cases of repeated interference, escalating from a Class C misdemeanor for first-time offense to a state jail felony for a third offense. The goal of this is to help law enforcement prioritize repeat offenders and to provide real consequences to deter habitual offenses. I think this is sort of a modernizing of the language in statute. That there was kind of a time where it was always kind of presumed that certain things were with the custodial and certain things were with the non-custodial, but we do see in real life that these things go both ways. And so this kind of modernizes the language and also creates a deterrent for repeat offenses. Thank you, Mr. Chairman, and thank you, members.
Members, any questions? Please show Senator Miles is present. So the chair now opens up for invited testimony on Senate Bill 2794. The chair calls Robert Garza, Brian Eggleston, Janice Eggleston, and Sandra Aguilar. Robert Garza, Brian Eggleston, Janice Eggleston, and Sandra Aguilar. So we begin on my right. Please state your name, who you represent, your position on the bill, and you may begin your testimony.
My name is Robert Garza. I represent myself. Interference with child custody has been and always will be illegal. Violating a court order has been and always will be illegal. Accountability is coming, and with that change is SB 2794, the 3 strikes law. Despite Texas Penal Code 25.03, interference with child custody being classified as a state jail felony right now, it's rarely enforced. In San Antonio, police receive 1,000 interference custody calls each month. Multiply that over 1,200 cities, and that's over 1 million calls. Police departments spend hundreds of thousands in county and city tax dollars having to hire more police every first, third, and fifth week to respond to these violations they cannot enforce because there's no consistent tracking of repeat offenders. The 3 strikes law fixes this problem. First offense, 500, second offense, 500, and the third offense, the state jail felony, what it is right now. This gives district attorneys a record of bad behavior and violations to show the grand jury. It also gives law enforcement the only tool that they have for this type of bad behavior. The bill also modernizes outdated language by removing terms like custodial and non-custodial, which should be replaced with any individual or person, and eliminates confusion during enforcement. What this bill really accomplishes is closing the loopholes that allow habitual offenders that continually withhold children from the other parent with no accountability. It moves custody interference out of legal limbo into enforceable law. We must support the 3 strikes law. This bill gives courts, law enforcement, prosecutors the tools they so desperately need, and the children the protection they deserve. When this bill passes, Texas will be leading the charge in putting families first. We cannot have a strong nation without having strong families.
Thank you. Thank you for your testimony. You get the microphone next to you so we can hear what you have to say. Your name, your position on the bill, and who you represent, and please proceed.
Sure. Thank you, Mr. Chairman. I appreciate that. Senators, thank you for having us today. Senator Paxton, I want to say thank you for sponsoring this bill. My name is Brian Eggleston. I'm a family law attorney here in the great state of Texas. Been doing this for about 15 years. This bill I'm in favor of. And I'm in favor of it because what it does is it does modernize an issue that's going on, but more importantly, it helps sort of this crossover on the penal side, the criminal side, and the civil side. Family law is 100% civil, yet we have people that don't follow the rules. We have people that don't do what they're supposed to do. In fact, parents, when they get divorced, when parents are in a custody case, they spend a lot of time and effort to get a document. That document tells both parents when they are supposed to have possession and access of their children. That seems great, and it seems amazing. And if everyone just followed that, I would be without a job, and we wouldn't be here today. Truth of the matter is, they don't. And when they don't, what happens is very simple. One parent unilaterally decides they are no longer going to follow a court order. The judge has signed this document. This isn't something they made up. They didn't go on Twitter or TikTok and they decided to, come up with some idea and this is what they're going to do. This is a court order and one parent has decided, I'm not going to do it. And that leaves the other parent in a really bad situation, because that other parent now has to, one, call the police. When they call the police come out and they say, hands are tied, this is a civil matter. What's interesting is the document in which they got signed by the judge, that court order says that law enforcement officers are able to enforce this order, but they don't. And so the parent that's being denied possession access has to come hire someone like me. And we have to go to court. And there are rules. There's a docket. This takes months, thousands of dollars. All, in some instances, while having no access to the child that they are lawfully entitled to have possession access of. So they have to wait. And then they get in front of a judge, and the judge says, well, this was 2 months ago. What took so long? And most judges are hesitant to do things that are necessary to remedy the situation. So what this bill does is stops that process. This allows officers to have an opportunity to do something, and allows them to go out, boots on the ground, and say, sir or madam, you're supposed to turn over this child, you'll turn over this child, and you will receive what is ostensibly a traffic ticket, Class C misdemeanor. And that person will be afforded all the rights under due process under this great state. And if they can prove that they had a good basis to do it, then they likely will not have to deal with that Class C misdemeanor. However, if they are found guilty, not once but twice, and they continue to do this, the third time it will be a state jail felony, which, by the way, is what already occurs under 2503. This is just giving law enforcement an opportunity to do something about it. More importantly, it enables parents who are citizens of this great state the opportunity to ensure that they have the ability to see their children based on that court order. Thank you.
Thank you for your testimony.
Good morning. My name is Janice Eggleston. I am for the bill. I represent myself. I'm a family law attorney. My husband and I have had a family law firm in Travis County for 15 years. I have represented hundreds of parents that have spent an exorbitant amount of time, money, and effort to get this court order in place. Family law attorneys are expensive. We deal with cases where we're in litigation for years at a time. We go to trial. We have judges who have heard all of the evidence in the case, make a determination about what is in the best interest of these kiddos. So important, we wrote it down, had the judge sign it, and these are the rules that we're supposed to play by. Judges go away, the lawyers go away, and feelings come into place, and people feel like they don't have to follow these orders. Unfortunately, not everyone has the financial means to hire an attorney and to go into court. And yeah, you can represent yourself and try to go in and do an enforcement, but those rules are pretty particular. It's a pretty big onus to ask someone to do pro se. I do dozens of consultations with potential clients on a monthly basis that are looking for help. When I explain what their remedy is, they don't have the means to proceed. What does that mean? It could mean months, even years of not seeing their child. By the time they get the money together or can borrow the funds to go and hire an attorney and go into court, there's no telling what the relationship with their child has changed into. Oftentimes it's become non-existent. So you go in, you finally file the enforcement, you get in front of the judge, and the judge says, well, you've not seen little Billy or Susie in months or years. You can't just expect this child to go over to your home. Now we're in the middle of a modification. We're talking about reunifying the parent with the child. By passing this bill, you guys are doing several things. You're providing an immediate deterrence. Sometimes just being told by an officer that there is a criminal penalty for not following the rules is enough. You're allowing the parents to have a faster peace of mind. We've got teeth now in the order. Instead of filing an enforcement, having someone served, setting a hearing, and waiting, this is something that can happen immediately. And finally, it lowers cost and results in fewer trips to the courthouse. Thank you for your time.
Thank you for your testimony.
Thank you.
Please proceed. If you can put the microphone.
Yes, I can do that. My name is Sandra Aguilar, and I'm a licensed therapist. I'm here representing myself and other therapists who work on what we call in these cases high conflict cases. Every day when I go to work, I work with families who are torn apart due to custody conflicts. I'm here today because I believe that this bill, Senate Bill 2794, isn't just a policy. It's a lifeline for children trapped in the middle of the conflict of their parents and these adults. And I'm here in support of that. Every week, police departments get phone calls about I can't see my child, what do I do? And parents aren't able to know exactly what to do in those situations. And when a parent willfully, let me backtrack. I think we would all agree here that if there is a protective order on a case, that parent should comply with that protective order. And if they don't comply with that protective order, there are consequences for that. This is a decree. It's a court order where parents agree to facilitate possession and access of their children. And when they don't participate and they don't share that custody, there are currently no consequences when they make that phone call to the police. And these parents typically are willfully withholding the child and the children from the other parent. And by the time that, as you heard both attorneys talk about, by the time it gets to the court system to do something about it, it's too difficult. At that time, we need to think about reunification or family therapy. But now we have another bill that's going to be heard here that's 3798 or 89 that has to, 3783 that has to do about not going and doing reunification therapy or family therapy. Yet this bill is the first line of what these parents do if they begin to withhold, because that is what mostly impacts this situation when you begin to withhold. It's the domino effect of what happens next in these cases. And they're the children are in the middle of this battlefield. They are often waiting for a police officer to say, no, you have to go see your other parent, because that gets them out of the battlefield. What do we do with our soldiers? We get them out of the battlefield. And with children, we leave them in this conflict. I support this bill, and I support what Mr. Garza's doing.
Thank you, members. Any questions? Thank you for your testimony.
Thank you.
Thank you all very much for being here. Thanks.
No more invited? Chair sees no one else registered for invited testimony, so invited testimony is now closed. Chair now opens for public testimony. Chair calls Michelle Wingard, Scott Russell, George Saldana, and Christopher Perricone. Yes.
Oh, I signed up. My name is on the list. I signed up last minute.
And your name is?
Claudia Ovias.
You're on the list. Thank you. Michelle Wingard, Scott Russell, George Saldana, and Christopher Perricone. We'll begin with you, sir, and you state your name, who you represent, your position on the bill, and you have 2 minutes.
Yes, sir. My name is George Saldana. I'm in support of the bill. Hello, my name is George Saldana, and I'm here today in full support of Senate Bill 2794. My journey in advocacy with interference with child custody began September 1, 2017. Since then, I've spoken to numerous state representatives, senators, and even district attorneys, including the District and County Attorneys Association, about this specific issue. I visit some of your offices before. My interference issues come from Harris County. The law has been on the books for over 50 years, and while it has evolved, we still face major problems. Enforcement. No matter how many good laws this legislative body passes, the judicial branch refuses to enforce them. If law enforcement refuses to act, we leave parents powerless and children caught in the middle. Texas Family Code 151.001 clearly states parents have a right to possession and access of their children. Section 151.003 says no state agency shall have a policy that violates your right. Yet, across state Texas, law enforcement agencies routinely ignore court-ordered custody arrangements, Parents are told to hire an attorney and seek another order that often ends up being ignored, just like the same. I appreciate the change in the bill from non-custodial parent to simply parent, but I suggest going forward further and using the term person. Many times it's not a parent, but another family member, like a grandparent that the child stays with, or even a friend who refuses to return the child. The word person would help close the gap and avoid further amendments and keep it uniform to the law as it is now. We passed House Bill 969 last session, and with cities like Laredo, with Professor Paul Boutron helping, and El Paso adopting these ordinances, but there's been no enforcement, no tickets issued, no metrics collected. We have no real data to show the scale of this problem. In other words, we can keep legislating these bills, but once we leave the Capitol and we get into the real world, law enforcement isn't going to abide by these legislative.
Thank you.
Thank you, sir.
Thank you for your testimony. Your name, who you represent, your position on the bill. You have 2 minutes.
My name is Michelle Winger, and I represent myself, and my position is against. I'm here to speak as a mom. When I read this, I get very concerned. Or where are we looking out for the best interest of the children when we're jailing parents? I don't have enough time to completely go into my case, but I could easily have seen my children, my case, falling into this gray area, intent to interfere. In my case, I did have my children at one point afraid to get in a car with someone who drove violently and actually injured one of the children. That was documented. Their refusal to want to go back into that situation and saying, we're afraid to get in the car, could have landed me in jail. Just where and how would that have benefited my children, quite frankly, when we were trying to reunify the family at that point? We were following the court orders. There was no intent. There was no, I don't want to, these are my children, they're his children. We were trying to keep our family together. And this would have had a real chilling effect. These children had a legitimate reason to be in fear. That needed to be looked at, and that did get addressed, and we were able to resolve it. I fear, had I been subjected to, I could be thrown in jail, lose my job, lose everything, the chilling effect that would have had on all of us. The process worked. We worked it all out. No one went to jail. No one lost a job or a home. My children were not further traumatized. I think we need to take a real look at this. It's not so black and white. Not everyone has an intent to interfere and withhold. I wanted to put my family together and keep it whole. I truly did. This process is very difficult. This would make it worse, much worse. Thank you.
Thank you for your testimony. You can move the microphone. Name?
Yes, sir.
Who
My
you
name
represent,
is
position on the bill, and 2 minutes.
My name is Christopher Perricone. I am for this bill. I've had the unfortunate suffering of living through over 1,000 times when I'm not able to pick up my children. I have documented, and this is a quarter of what I have, hundreds of offense reports from no less than 29 different police officers, all citing interference with child custody 2503. The problem is not in necessarily the law. I will submit and echo the same thing George did. It does need to be persons, in my opinion, because that also goes right alongside of the Texas Family Code 42002 and 003, which states person. It doesn't use the word parent. So that's the counterpart on the civil side to the Penal Code 2503. So highly recommend using person. But the real issue comes down to the enforcement mechanism of all this. The legislative branch, y'all's power is being usurped, in my opinion, from what I see in my court orders and everyone else's orders, by this notice to peace officers that they may enforce, that they may write. It took an act of Congress almost to get just a report for interference with child custody, and I was supposed to pick my children up at the police department where it's verified prima facie evidence by officers, no less than 29 of them, including the police chief, verifying with their own eyes that she's not there, she was given notice about it, she just chose not to come. And then if we don't have a way to enforce it, and then it's worthless to us. So as a legislator, that would be one help, to change that boilerplate language that's in every order that says you may enforce it. At least force them to write down the criminal offense complaint and then initiate a fine or something first. That's my biggest frustration is there is no enforcement. So please, the DA told the police not to enforce it, and the judge on the judicial side has told the people not to just.
Thank you for your testimony.
Thank you.
Please proceed.
My name is Scott Russell, and I am in favor of the bill. Chairman Flores, thank you so much. Senator Paxton, thank you so much for your leadership on this. I'm a father of 4 from Keller, Texas, and for too long, our laws have created a double standard in child custody enforcement. Custodial parents routinely violate court orders and possession schedules, fully aware that there's going to be really little real risk of consequence. In my own case, I've lost over 400 hours, 400 days with my children, days I'll never get back. And the process dragged on for so long, I was forced to file an enforcement action. And during that time, my oldest child turned 18, and I'll never get any time back with him as a result. That enforcement action took 8 months to complete and tens of thousands of dollars. And as soon as I filed for that enforcement action, my ex-wife, Nicole Russell, filed for modification to try and go back to court and take more of my time away from my children. The court ultimately held her in contempt for 19 separate violations. She was sentenced to jail for 30 days for each one to be served concurrently. And then the judges suspended the sentence. It just said, don't do it again. So it was just a slap on the wrist. She walked out of court that day with no consequences whatsoever. If I miss a child support payment, which I never have, but if I do, and that starts to accumulate, you take my driver's license away, you take any other license away. I can't fish or hunt in the state of Texas, and I can go to jail for that. But there's no reciprocity on the other side, for she is not allowing me to spend quality time with my child. I feel like Senate Bill 2794 is a critical step forward. It removes the biased language that protects custodial parents from being held to the same legal standard, and finally recognize that either parent can interfere with parenting time. Thank you so much.
Thank you for your testimony. Members, any questions? Thank you all very much.
Thank you all for being here. Thank you very much.
Chair now calls Claudia Ovalles and Rachel Burgess. Claudia Ovalles and Rachel Burgess. Show Senator Huffman is present. Rachel Burgess, are you, you're Ms. Ovalles? Rachel Burgess? Rachel Burgess. Please proceed. Your name, who you represent, your position on the bill. You have 2 minutes.
Thank you, and good morning. My name is Claudia Ovalles. I'm here today to support SB 2794, the Three Strikes Law. In 2023, during the 88th regular legislative session, I proposed and passed House Bill 969, relating to local regulations to enforce child custody orders authorizing a civil penalty. The bill passed unanimously in the Senate. The bill addressed a significant problem in Texas, interference with child custody. You may be wondering what that is, and I know that others have touched on it, but in a nutshell, it's when a parent or individual unjustifiably interferes with child custody or parenting time. In the public record request I conducted from the city of San Antonio that ranged from 2018 to 2021, on average, there are 1,000 calls each month to law enforcement on visitation violations. So if you think of that, at least 1,000 children are denied a relationship with the other loving parent. Now think how that expands throughout the state of Texas. My son was one of those children, and the damage to our relationship was profound due to my former spouse's alienating behaviors and his continuous noncompliance with our court order. As a loving parent, you expect a court order to be upheld after a divorce, and that co-parenting your child would be honored. That's not always the case. What Senate Bill 2794 accomplishes is closing the loopholes that allow habitual offenders to withhold children from the other parent with no accountability. My law was not mandatory. It allowed municipalities to enact a civil penalty. However, getting 254 counties to enact a law would take too much time, allowing too much damage to parent-child relationships. SB 2794 enhances the law and provides a stronger tool for law enforcement. SB 2794 also introduces safeguards for parents, and I know that Mother mentioned it, but there are precautionaries in the law. The parent-child contact refusal dynamic can adversely affect children and has become a significant public health issue. Children who have been alienated from a parent experience substantial losses across many areas of their lives. Research data exists on this issue, and I would be happy to share those resources. But in the meantime, please vote yes on Senate Bill 2794 and protect parent-child relationships in Texas.
Thank you for your
Thank you very
testimony.
much.
Any questions, members? Thank you. One more time for Rachel Burgess. Rachel Burgess. With that, the chair sees no one else registered for public testimony. Is there anyone here who wishes to testify on, for, or against Senate Bill 2794? Hearing none, public testimony is now closed. We'll leave the bill pending. All right. Now. Chair lays out Senate Bill 2105. The chair sends up the committee substitute for Senate Bill 2105. Is there any objection to adopting the committee substitute for Senate Bill 2105? Hearing none, so ordered. Recognize Senator Blanco to explain the bill and the committee substitute.
Thank you, Mr. Chairman, members, for allowing me to lay out Senate Bill 2105. Well, the committee substitute for 2105. El Paso and other parts of the state have recently seen disturbing examples of human trafficking tied to commercial lodging establishments. In October of last year, a woman was arrested at the Gateway Hotel in El Paso for drugging and forcing a migrant into prostitution. Although the victim reported the abuse to the hotel staff, they dismissed her concerns and they took no action. Just a couple of months ago in February, federal agents uncovered a human smuggling ring using multiple motels to hide undocumented migrants, resulting in several arrests and the recovery of trafficking victims. These are not isolated incidents. Hotels and motels across Texas are frequently exploited by human traffickers, yet many continue to ignore state laws requiring their employees to undergo human trafficking awareness and prevention training. So this bill addresses this gap by allowing counties and district attorneys to bring civil actions against non-compliant hotels and motels, serving as force multipliers for the Attorney General's office, which currently holds sole enforcement authority under existing law. The committee substitute developed in collaboration with Senator Huffman and the AG. This requires local prosecutors to notify the AG before filing suit by giving local officials the authority to enforce those laws. This bill helps protect vulnerable Texans, holds bad actors accountable, and makes our communities safer. We do have resource witnesses from the Attorney General's office here to answer any questions. Mr. Chairman and members, I thank you and ask for favorable consideration for this bill.
Thank you. Any questions, members? Any questions you might have for the resource? We need to bring them up. Thank you. Thank you. Thank you, Senator Blanco. Chair now opens up for invited testimony, and if there's no need to speak to the resource, I show no one else for invited testimony, so invited testimony is now closed. Chair now opens up for public testimony for Senate Bill 2105. Chair calls Aaron Setliff. Aaron Setliff. Thank you for being here. And Justin Bragil.
Close enough.
Close enough. Mr. Setliff, we'll begin with you. For your name, for the record, your name, who you represent, your position on the bill. You have 2 minutes, sir.
Thank you, Chairman Flores. My name is Aaron Setliff. I'm the division chief in the El Paso County Attorney's Office. I'm in favor of the bill. So I am a current division chief in the county attorney's office, but I was a former border prosecution unit prosecutor at the DA's office for several years, and I was the human trafficking designated lawyer over there. I want to thank this committee and the entire Senate and the legislature for its commitment to addressing the problem of human trafficking. I also want to take the blame. I've given you a one-pager, and I made a pen and ink change because I had the wrong bill number. That's my mistake. I apologize for that. 2105 is the one that the one-pager is in front of you on. So the short of it is that human trafficking too often happens in hotels and motels. It's either facilitated or it happens under the watch of managers and others that work at motels and hotels. I think of an example of one of the cases that we tried in the Border Prosecution Unit. William Thacker kidnapped a young girl, a minor, and brought her from North Carolina all the way through several states to El Paso, landed at a local motel, and stayed there for several months. I think about if that motel had had the kind of training that we're talking about. This was prior to the passage of the statute last session. But if they'd had that information, I would hope that some of the red flags would have arisen prior to the incident that we ultimately caught him for while he was running from DPS in a rural part of El Paso County. We tried and convicted him, and so we're thankful for that. But it could have ended sooner. So the law currently requires that human trafficking training happen in lodging establishments. That's the law. The Attorney General's office, we thank them for the many online tools that hotels and motels can get on and get that training for free. We looked at several hotels and motels in El Paso last year. We found 5 that were not compliant and had not complied. So we wanted to step up and help the Attorney General's office in holding those hotels and motels accountable by filing civil injunctions against them, either for fines or other alternatives to encourage them to do that. This is nothing against the Attorney General's office. The county attorney's office in each of y'all's areas knows their communities best and can step up and help with that injunctive relief. I thank you, and I ask that you support the
Thank you for
bill.
your testimony. Thank you for taking the time for what you do in El Paso County and for coming all this way to testify.
Thank you, Chair.
Thank you.
Good morning, Mr. Chairman, Senators. My name is Justin Bregel. I'm General Counsel for the Texas Hotel and Lodging Association, here in support of Senate Bill 2105. So in 2021, we worked with Mrs. T to write this chapter into the law. A lot of this language is actually ours. And we're fully supportive of Senator Blanco's efforts to strengthen the compliance with this. We felt it was so important to write into the law in the first place. Having it not complied with is a real problem. And so we welcome working with our partners with the district attorney's offices and county attorney's offices across the state of Texas. Human trafficking training, prevention training is vitally important. This legislation in Texas is actually based off of national legislation that our national association came up with. So it's something we're committed to doing. Human trafficking activity unfortunately does occur at lodging establishments, but we do everything we can to stop that from occurring wherever possible and certainly work with lodging establishments and law enforcement officers in order to root it out. So I'm here to answer any questions you all may have about the bill or about the program.
Thank you. Members, any questions? Thank you all for being here.
Thank you.
For your testimony.
Thank you both.
The chair sees no one else registered for public testimony. Is there anyone who wishes to testify on, for, or against Senate Bill 2105? Hearing none, public testimony is closed with the bill pending. Let's see who we got next. It's Menendez. Chair lays out Senate Bill 155. Chair sends up committee substitute for Senate Bill 155. Is there any objection to adopting the committee substitute for Senate Bill 155? Hearing none, so ordered. Recognize Senator Menendez to explain the bill and the committee substitute.
Thank you, Mr. Chairman. Members, there's a committee substitute, Mr. Chairman.
So recognized. We just
Okay. So
adopted it.
what we have here is a refile. Committee substitute Senate Bill 155 that's been titled the Ramon Nájera Act was filed in response to a violent dog attack that ultimately took Mr. Nájera's life. On February the 24th, 2023, in San Antonio, Ramon Nájera, who's 81, was with his wife Juanita, 74. They were viciously attacked by 2 dogs as they were trying to get into their vehicle. after they had gone to visit a relative. Both individuals were mauled. Mr. Nájera ultimately was killed. A relative who was helping suffered a bite to the hand, and a firefighter had a punctured leg. In San Antonio alone, it has been reported that over 16 dangerous dog attacks since Mr. Nájera was killed, including those which seriously injured and maimed or killed San Antonians of all ages. One of these attacks occurred just last week. Currently, in order for a concerned citizen to report a dangerous dog in their neighborhood, they're required to provide an affidavit or a sworn statement. Unfortunately, this lack of anonymous reporting deters people from reporting dangerous dogs, especially because of the potential owners who have criminal records. In the case of Mr. Nájera, the owner of the 3 pit bulls had threatened his neighbors and had known criminal activity. After conversations with stakeholders, including the governor's office, the committee substitute makes the following changes. It titles the bill that Ramon Nájera Act. It allows the Animal Control Authority to investigate an incident by observing and documenting the behavior of the dog. Additionally, after determining a dog is dangerous, the Animal Control Authority must notify the owner in writing of the determination. The identifying information of a witness who gives a sworn statement is confidential and is not subject to disclosure under Chapter 552, Public Information, and may only be disclosed for purposes of enforcing the chapter to the governing body of the municipality or county where the incident occurs. Currently, the bill is bracketed to the city of San Antonio because in last session, when we passed this bill and it got to the governor's desk, City of Houston and Dallas said they didn't have a problem with this and they didn't want to be in the bill. If a repeat attack occurs, punishment could be a Class B misdemeanor. And like I said, this bill came out of this committee last session, got to the governor's desk. Obviously, a lot of bills got caught up in some situations, and this was one of those. We've been through the stakeholder process. We worked with the governor's office, and we hope that this bill will have the ability to be signed into law. Today, we do have Mr. Davenport here with Animal Care Services. He's the Assistant Director for the City of San Antonio, testifying and able to answer any questions of why this is such a problem. Members, you know, some of y'all know that I served as a city councilman back in the late 90s in San Antonio. Even back then, we had a problem with people being able just to walk in their neighborhoods. We have a serious problem. Some people actually believe it's okay when they leave for work in the morning to open the door, let their dog out, and let the dog run the streets. And they think it's just perfectly fine. And what it does, it takes the ability for everyone else to be able to use their sidewalks in their neighborhoods. And that's why we have this bill again. Thank you, Mr. Chairman and members. I'll be happy to answer any questions.
Senator Hinojosa.
Thank you, Mr. Chairman. This is a very serious problem.
Yes, it is.
But I saw it's on the bracket of San Antonio, and
If your communities want to be in it, as long as the governor's office is okay and your communities are okay, I'm happy to let you in.
Yeah, I think the Rio Grande Valley, it's a serious problem down there too. So,
we just did this because Dallas and Houston were against the bill up until the point that we let them out. They said they didn't need our help. But if you want in, I'm happy to let anybody in. I think this should be a state law, as long as the governor doesn't, is okay with his staff with not having the bill vetoed.
Thank you.
Thank you.
Thank you. Any other questions, members? If not, Chair now opens up for invited testimony. There's no one registered for invited testimony, so invited testimony is now closed. Chair now opens up for public testimony. Chair calls Brad Davenport and Hasib Abdullah. Brad Davenport and Hasib Abdullah. We'll begin on my right. And state your name, who you represent, your position on the bill. You have 2 minutes, sir.
Thank you, Chair. Chair, members, my name is Hasib Abdullah. I will represent myself, maybe my extended family as well. My parents in Northwest Harris County, where I was born and raised. I'm a sibling in Lucas, Texas, along with 3 nieces there, and another sister in Cedar Park, Texas, under your jurisdiction, actually, Chair Flores. And I am in support of Senate Bill 155. Thank you, Senator, for bringing it. But as the discussion was talking about, I'm very concerned that this isn't statewide. I know neighbors personally who've been severely injured from dog bites. I know this is more of a narrow bill that talks about the anonymous reporting, but currently, many municipalities I've noticed are spending an order amount of time passing, counties and cities passing bills that a dog has to bite someone or even a child 2 or 3 times before they're either put down or taken away off the streets. I know, I think everyone in all corners of Texas know of some type of serious dog bite that's happened. I definitely think that if there is an issue of raising animals in a dangerous situation, creating almost monster dogs, that should be adhered to with another bill. But I'm very supportive of this, but I just would hope that the senator in this body and chair and vice chair would send this statewide, because this is very needed at this time. Thank you.
Thank you for your testimony.
Thank you. Good morning, Chairman Flores and committee members. My name is Brad Davenport. I'm the Assistant Director for Animal Care Services with the City of San Antonio, and I'm here today to show support for Senate Bill 155 by Senator Menendez. The City of San Antonio has experienced multiple dog attacks over the last few years that have resulted in life-altering injuries and, in a couple cases, death. Although the state of Texas has good dangerous dog laws, this bill would help enhance existing law and provide methods to prevent and significantly reduce future attacks. The City of San Antonio has over 2,000 dog bites reported annually. San Antonio currently has 186 deemed dangerous dogs, and we receive approximately 40 dangerous dog affidavits monthly. While half of these cases result with an owner surrender, the remaining owners choose to keep the animals while meeting state and local requirements. By letting the owner know that failure to comply with these requirements can result in higher penalties, we believe we can incentivize residents to strictly adhere to the requirements or consider surrendering the dangerous dogs before they hurt an individual. This bill also includes a section that allows for San Antonio to designate a dog dangerous if appropriate. In the last year, we had a case where a child was playing in their front yard and the neighbor's dog ran out of the house and attacked the child. The bite did not cause severe bodily injury, however, was still traumatizing for the child. The parent of the child and the dog owner had been neighbors for some time, and because of that, the parent would not complete an affidavit. As you may already know, we've had 2 tragic deaths over the last 2 years, which initiated our process to seek help from this body to enhance state laws. This bill is a crucial step towards safeguarding our community and holding irresponsible owners more accountable. I want to thank Senator Menendez for their advocacy on this matter, and I'm available for any questions that you may have.
Thank you. Thank you for your testimony. Any questions, members? Thank you all very much for being
Mr. Chairman, very briefly, Mr. Chairman.
Yes, Senator.
I wanted to ask the gentleman, my understanding is that, and you just remind me with that last anecdote, we had a situation, and it may have been in Converse, where there was a dog that was traumatized in the neighborhood, just running the streets, and finally one of the neighbors, after getting no help from local law enforcement, do you recall this person ended up shooting the dog? Didn't that?
I don't know about that one specifically. We've had multiple dogs shot this year by neighbors.
Yeah, so that's the problem. When we don't get in and give them protection, people will take the law into their own hands. And that's one of the concerns that I have. Thank you.
Thank you. Thank you for your testimony.
Mr. Chairman, can I ask a question?
Senator King.
Thank you.
He's going to ask a question if y'all would just wait just 1 minute.
Yeah, actually, the gunshot sounded like a pretty good remedy. We were just thinking, but okay, the 2 death cases that were mentioned, that Senator Menendez and you mentioned, which are horrible and never should have occurred. How would this, if this bill had been in place then, what would this have done to prevent that?
So what this bill would allow is for ACS to investigate the animals and deem them dangerous, so they're notified. So these dogs had attacked previously multiple times. In this case, by the time the dog attacked a second time, it would be up to a Class B misdemeanor, which would be possible jail time, and there would also be more conditions to get the animals surrendered to ACS.
Okay, what had? I'm just always trying to figure out why.
Mr. Chairman, I think I can answer the question.
Okay. I'm just trying to figure out what difference it would have made and what San Antonio had done
without a doubt
up to that point.
Senator King, so what happened, especially in the case of Mr. Nájera, his relative lived next door to a known drug dealer, okay? Both he and his wife have been convicted, and since this happened, they had threatened every neighbor around them, because ACS had been called because they had a habit of leaving the gates open and letting the 3 pit bulls run around. ACS had been called, and because when you make a report, it's not anonymous. Found out, went to visit the neighbor that made the report. And so what we've done in the bill is you can make a report, you do give your name and everything, but the purposes of the report in this bill are just for the purposes of the case for government reporting. So now the dangerous neighbor, the neighbor that's doing, because a lot of these incidents unfortunately occur in neighborhoods where there's a lot of other activities going on. And so these dogs are used for protection. And so, but the neighbors who are all around them are already scared of the people who own the dogs. And so what we're trying to do is have them be able to file this affidavit without fear of retribution from their neighbor.
Okay, and you can't do that by city ordinance?
They've done whatever they can. He could answer that question.
So we've done it at the administrative level for fear. I will say that they're subject to open records requests and disclosure if they appeal. But what this would also allow us to do would be able to investigate a case when a victim or witness is unwilling to come forward, but the city of San Antonio recognizes a public safety concern, and it's in the best interest of the community to take action and not just ignore it. Like the example I gave, the testimony of the child that was attacked in her own driveway, the parent didn't want to come forward. That dog had history of previous nuisance.
Okay, thank you, Mr. Chairman.
Thank you. Thank you for your testimony. The chair sees no one else registered to testify publicly. Is there anyone present wish to testify on, for, or against Senate Bill 155? If not, the bill is left pending.
Thank you, Mr. Chairman, members.
Chair lays out House Bill 3513 and recognizes Senate sponsor Senator Sparks to explain the bill.
Thank you, Mr. Chairman and members. This is a local bill that'll make changes to the Moore County Juvenile Board. Due to the rural nature of the county, it has proven to be difficult to have currently required 6 people plus a county judge appointed to the juvenile court and only have them serve one 2-year term. This bill would simply accommodate the rural population in Moore County and allow the board to be made up of 3 to 5 members of the public appointed by the commissioners' courts, plus the county judge and the county court at law judge. It also gives the commissioners the ability to extend a member's term 2 additional years and the authority to have a juvenile probation officer and necessary personnel if they deem fit. With that, Mr. Chairman, I'm happy to take any questions.
Members, any questions? If not, the chair now opens for invited testimony. The chair has no one registered for invited testimony on House Bill 3513. So invited testimony is now closed. Chair now opens up for public testimony. There's no one registered to testify for public testimony on House Bill 3513. Anyone here present wish to testify on, for, or against House Bill 3513? Hearing none, public testimony is closed. The bill will be left pending.
Thank you, Mr. Chairman. Thank you, members.
Yes, I have you right here. Chair lays out House Bill 2756 and recognizes Senate sponsor Senator Huffman to explain the bill.
Thank you, Mr. Chairman and members. Members, on November the 13th, 2023, Jovian Motley, a 27-year-old correctional officer serving at the Texas Department of Criminal Justice's Wainwright Unit, lost his life in the line of duty. Jovian was sent into a cell as part of a 5-officer extraction team to remove an inmate, but was the only officer from the team who did not survive. It is important that all correctional officers within TDCJ receive in-depth training so they can employ best practices and avoid tragedies like this. House Bill 2756 requires TDCJ correctional officers and their supervisors to receive pre-service and annual training on de-escalation, crisis intervention, and behavioral health. This training will touch on effective communication using alternatives to physical restraints, techniques to limit force, proper lighting, safety techniques during cell extractions, and fundamental life-saving procedures, amongst other areas. I'd like to thank Representative Symphonia Thompson and TDCJ and the Motley family. I believe Jovian's mom is here with us today, for working on this important legislation to increase safety procedures in our correctional facilities. If you've never seen one of these extractions, I had a case when I was a prosecutor, and there was some evidence, and so there was a film of this extraction in a cell, and the violence, it's unbelievable, the amount of harm that one person who's hell-bent on doing it can cause. It was startling to me. It was frightening. So I can't imagine what it must be like to gear up and to go into those cells. So I think this is a very important bill, and I think it goes a long way towards making TDCJ a safer place for those who are willing to take these jobs, and we are forever grateful for them for willing to work in the prisons for us. And that's my layout.
Members, any questions?
Yes.
Senator Hagenbuch.
Thank you, Mr. Chairman. Yeah, we need to protect these folks, and terrible example. Thanks for sharing it with us. The only question I have is I'm just surprised almost that everything you said seemed like almost basic training they would have. I'm a little surprised we don't already have a lot of that when a new person comes to be working in a.
And I'm sure someone from TDCJ can speak to just the basic training. I think this is very specialized. Like I said, until you've kind of seen it, it's hard to believe, because you just go into a closed area and they're suited out, but the amount of violence that one individual it's just like they lose it. It's hard to explain. I bet. I see Brian Collier shaking his head. Yeah, it's almost, we should all have to look at one of those. It gives you a better understanding. That's why when I have an opportunity to give those guys a raise, if we're doing it again this session, I'm always willing to do it, because they earn every penny that they make. Thank you.
Thank you, Chair.
Thank you. Chair now opens up for invited testimony. Ayanna Motley. Ayanna Motley. Good morning. Good morning. If you state your name for the record, who you represent, and you may begin your testimony.
Okay. Good morning, members of the committee. I am Ayanna Motley. I am the sister of Jovian Motley, and I am for the bill. So first, I want to thank Senator Huffman for bringing this bill forward. It is very dear to me because Jovian Motley was an all-around light. On duty and off duty, he was a protector. As much as I didn't like to admit to my brother, I looked up to him for many things. One namely being his courage and his protective nature. It is very important to me that these parts of his legacy lives on. And this is an important step. Excuse me. Not just for my brother, but and our family, but other families as well, and officers to follow. Many officers have to have the proper training and the resources that will help aid in preparing them for these types of extractions and events therefore. So, excuse me. Yes, so it takes a lot of courage and pride in order to trust in these policies, in the training, as well as the team, in order to do these things. And so it's very important that we provide that so they can effectively protect and serve, as well as make it home to their families. Thank you all.
Thank you for your testimony.
Thank you. No questions.
Senator Hagenbuch, did you want to Director Collier to come up and answer your question, or are you satisfied with?
No, I think I'm satisfied, regardless of whether someone thinks that maybe should have been in the basic training or it's not. So this is important to put into it. So yeah.
Thank you, members.
Yeah,
any other questions? If not, the chair calls Tamika Motley. Tamika Motley. Good morning.
Morning. You say my name like my mom. Good morning, Chair Flores, Committee. Tamika Motley, the mother of Jovian, and I'm here to speak on for the bill. Again, my name is Tamika Motley. I am the proud mother of fallen correctional officer Jovian Motley. I would first like to thank Senator Huffman for bringing this bill before the committee. On November 13, 2023, Jovian tragically lost his life in the line of duty while performing a cell extraction trying to remove an unruly person from a dark cell. The need for continued de-escalation and mental health training is crucial when just one day before there was a disturbance with this same inmate and yet another officer was able to effectively de-escalate. What was the difference? What was the rush to send officers into a dark cell? I urge any of you that have any questions to please request to see the video of this extraction. The lack of patience and concern for safety speaks volumes. With this officer, he threw caution out of the wind, which in turn cost Jovian his life. This bill places priority on safety. Corrections is a very dangerous job. Therefore, we cannot cut corners on safety. Jovian was 27 years old, full of life. He had a life ahead of him that only one could imagine. He was loving, dedicated to his job. He should have made it home that night. Now there will forever be an empty seat at our table. We will never get to see him get married, have kids, or move through the ranks in his career as he planned. All of that was cut short because of a lack of judgment by a lieutenant who has now been terminated for his actions in yet another use of force, even after Jovian lost his life on his watch. This bill sends a message that we will not allow another officer to die due to a lack of training or judgment. So on behalf of my family, we ask that you please pass House Bill 2756 and give our family some comfort in knowing that Jovian's death was not in vain, yet it is a catalyst for change. With that, I will close, and I'm open if you have any questions.
Members, we thank you, and we honor you, and you honor your son.
Thank you.
With not, the chair sees no one else registered for invited testimony. Invited testimony is now closed. The chair now opens up public testimony. The chair calls Lauren Johnson. Lauren Johnson. If you state your name, who you represent, position on the bill, you have 2 minutes.
Hi, good morning, Chair and members of the committee. My name is Lauren Johnson. I am the Justice Director at Dream.org, who I represent as well as myself in support of the bill today. Dream.org is a national nonprofit. We work at the intersection of poverty, prisons, and pollution. And we will work with anybody to help create the world that we all deserve to live in. We believe that everybody that is inside of the system has the right to safety and has the right to make it home to their families. And in a previous life, many, many moons ago, I worked as a rehab tech at the Brown School. And in order to attain that job, I had to spend 2 weeks going through training before I could ever set foot on the floor. And the Brown School worked with people that had neuropsychiatric disorders, brain injuries, et cetera. And in that lowly role that I had as a rehab tech there, in that 2 weeks of training before we could work with patients, they trained us on de-escalation tactics, how to use the least restrictive forces, things along those lines, because it was important to the safety of the patients that we worked with, and it was important to our own safety. I don't think that people that work within the prison system and the people who live there deserve anything less. I'm grateful to Senator Huffman and Dean Thompson for bringing this bill forward, and I hope that you will pass it favorably in memory of Jovian. Thank you.
Thank you for your testimony. Thank you for being here. Not the chair sees Chair sees no one else registered to testify publicly. Is there anyone here who wishes to testify on, for, or against House Bill 2756? Hearing none, public testimony is closed. We'll leave the bill pending. Chair lays out Senate Bill 1778. Recognizes Senator Miles to explain the bill.
Thank you, Mr. Chairman and committee members. for allowing me the opportunity to lay out Senate Bill 1778. In recent years, the use of telemedicine has increased access to care across the country. While TJJD does have access to telemedicine services, the facilities primarily use local providers to administrate care and physical alignment. These providers are usually only on-site at TJJD facilities once per week. Although there are healthcare providers available weekly, these facilities are remote, which makes it difficult to have specialist healthcare providers available. Further, according to the 2024 report released by the Texas Advisory Committee on the U.S. Commissions on Civil Rights, the facilities are having serious trouble training for special staff, like medical staff. Those that do stay are often pressed into what is functionally guard duty because of lack of high turnover among existing guard staff. That means if there's health concerns, these children have to go sometimes to wait if it not an emergency. The same report documented that a child that had slipped some objects beneath his skin and had pus running down his arm for 2 weeks. Members, I am not a doctor, but symptoms like this usually means that wounds is affected and the child should have immediately access to medical profession and can prescribe them some antibiotics. Senate Bill 1774 would address these terrible situations. The bill requires TJJD to contract for telemedicine services to be available when the physician advice, advanced practices, registered nurses, or physical physician's assistants is not present at the facility where the services are not provided. The goal is to address outpatient issues for these children immediately. We have Dr. Alexander Laws, a pediatrician from my district, who can answer questions you may have, and thank you for allowing me to lay out this bill.
Thank you, Senator Miles. Any questions for Senator Miles? So the chair now opens up for invited testimony. The chair calls Alexandria Laws. Dr. Laws. Good morning.
Good morning.
You state your name for the record, who we represent, and you may begin your testimony if you
Good morning, Chairman Flores and committee members. My name is Dr. Alexandria Laws. I am a pediatric resident physician in Senator Miles' district. I'm representing the Texas Pediatric Society as well as Texas Medical Association, and I'm representing myself as well in support of SB 1778. So we know that youth in custody face high needs, specifically in mental and physical health, compared to their non-incarcerated peers. Many in custody also have undiagnosed or poorly managed chronic conditions such as asthma or seizure disorders, further compounding their complexity. As a resident physician serving youth at the county level detention center, I witnessed these consequences delayed in care. I recall 2 recent cases that highlight just how urgent access to timely medical attention can be. One child came to our clinic with a severe rash covering their face down to their legs, an extreme case of eczema. The child had been unknowingly suffering for at least a week, unaware of the condition because their mother had always used hypoallergenic products at home. By the time we saw them, their skin was deeply excoriated and there were areas that could permanently scar. This case needed immediate attention and follow-up, something that shouldn't be delayed for any child. Another youth presented with a rash that initially seemed similar but turned out to be something entirely different, scabies. Treatment required not only medication but swift action to sanitize bedding, clothing, and to prevent the spread to the others in the facility. Both cases required prompt evaluation and prescriptive treatment. In the setting where symptoms often arise outside of clinic hours, children can suffer unnecessarily while waiting for care. Our hope is that the youth in the juvenile justice system, no matter the facility, have consistent, immediate care to physicians and/or delegated providers so they can receive the care they need when they need it. Telemedicine can fill this critical gap by offering timely and accessible healthcare services to vulnerable youth. Thank you for your time.
Thank you for yours. Any questions, Senator Miles?
Thank you for coming this day, Dr. Laws. I wanted to make sure and ask you just simply, telemedicine could be beneficial to the health care of our children that are inside our facilities, correct?
Yes, sir.
And it would take time off of your schedule for basically just simply observing the situation from a telemedicine unit.
Yes, sir. The examples I use specifically are ones that can be diagnosed via telemedicine. We know everything can't be diagnosed with telemedicine, but these are things that we can see via a computer, and we can diagnose and send prescriptions so they can get immediate care. So these are things that often happen inside these centers that we can address.
Could you speak to anything on the Committee of Commission on the Civil Rights Facilities having serious trouble retaining specific staff? Can you speak to that?
Yes, slightly. So I work at the county level, so I don't work at the state level. In the county level, we do have resident physicians, which is rare. No other facility that I know has resident physicians, and these are physicians in training as myself, as pediatricians. Others only have physicians or delegated providers. So as you can imagine, I have at least 200 resident physicians in my university. So we rotate through this facility, and there's at least 200 people there within a year. So take away those 200 people and then just put a couple providers or physicians. The kids are not getting as much care as they would that we see on a county level.
That's all I have. Dr. Laws, I want to thank you for being here today. Thank you.
Thank you for having me.
Thank you, Dr. Law. The chair sees no one else for invited testimony. Invited testimony is now closed. Chair now opens over public testimony. Chair calls Scott Lepore.
Good morning, Scott Lepore, Medical Director for the Texas Juvenile Justice Department.
Any questions? Any questions, members? Senator Miles.
You're testifying as an expert witness?
He's testifying on public testimony, but he's here in that capacity as well.
Thank you.
Yeah.
Okay.
What's that? Can I ask a question?
Sure.
So it sounds like this bill would be for the counties, detention centers. I was under the impression it was for secure facilities. I just want to be clear because I'm happy to give any information on what was presented and the differences between secure facilities and the counties.
No. Senator Huffman.
Yeah, so now I'm confused. Is this for the secure facilities? It is for both? Yeah, okay.
It's for both, is that what I heard?
That's what he's saying, yeah.
Okay.
Which is what I thought too, which is, yeah, it's probably needed on both. But,
Yeah, may I address that?
Let me ask you a question first, and you can ask.
Oh, for sure.
So the doctor testified about some skin diseases and definite, so that there would still be some clearly illnesses or symptoms that were presented that. Who makes a determination whether it should be telemedicine or needed to be seen by an actual physician? I mean, that's the part I'm sort of.
Yeah,
You
so
just
it could
start with telemedicine, and then the doctor says, "I can't do this."
And that depends. So it would be dependent about how you set up that protocol. So maybe if you have nursing, who is triaging that patient?
Yes, yeah.
And maybe it's a phone call to the provider, then the provider would ask, let's get the youth to telehealth, and let me take a look.
Okay.
I
mean, I'm very supportive of the bill. I just don't want the telemedicine to become like a crutch, right? And then some kid presents with something that's maybe, internal or something. And
so that would be the
stomach ache, but it's some internal injury.
Correct. And I think that's the delineation for me. So we prefer, those are county cases that would not be secure facility. I am absolutely for extending health care to be provided for any of these youth as much access as possible. So, and I appreciate you again for bringing this back to the table. For secure facilities, we have, all of our psychiatric care is provided by telehealth, and they are in the infirmary, those rooms. So we have access to it. So let's say a provider, and we schedule our on-site visits for our medical providers 1 to 2 days a week, depending on the need. So if there's a youth that needs to be seen, they'll be seen. Where the telehealth can be used by medical is, let's say that a youth calls in at night, they have a sick call complaint, but it's not emergent. Then we will see that youth the next day. If that medical provider is not on site, then they will the nurse will see the youth and call the provider, give them information, and that provider has the discretion to say, hey, I'd like to see the youth. Okay. And they'll go over to the telehealth room. So we do have access to it and utilize it. So I apologize. I thought it was just for secure facilities, but absolutely it would be beneficial to have any access for these youth.
All right.
Yeah.
Thank you. Any other questions, members? Thank you. Thank you for being here.
Yeah, for sure.
I see no one else registered for public testimony. Does anyone wish to testify on, for, or against Senate Bill 1778? Hearing none, public testimony is closed. We'll leave the bill pending. Chair lays out Senate Bill 2017 and recognizes Senator Betancourt to explain the bill.
Thank you, Mr. Chairman. The members, street racing and reckless driving was addressed by the legislature with the passage of House Bill 2899 and 1442 last session. These are a continuous problem, certainly in the urban areas. But what was not addressed in the statute was literally burnouts and wheelies, leaving law enforcement with limited tools to deter this behavior. Burnouts and wheelies have become the new rage, piece of resistance, and they are causing unsafe driving environment for anyone traveling in the roads in Texas. So Senate Bill 2017 would create a criminal penalty for the performance of burnouts and wheelies. This would be a Class C misdemeanor, and I do have a resource witness here, which is Sergeant Scott Hewitt. Be happy to answer any questions.
Thank you. Any questions, members? Senator Hinojosa.
What is a wheelie?
Well, I haven't done it in a while, okay, but I've been able to, back in the old days, pull up a bike or a motorcycle or even a car occasionally and work on just the back wheels for an extended period of time.
Okay.
Okay, that's right.
Thank you.
Thank you. So if no more questions of Senator Betancourt, and we have for invited testimony of Scott Hewitt for a resource. If anybody has any questions.
Scott, since you're here real fast.
Why don't you come forward,
come on up, just say,
Sergeant? State your name and who you represent for the record.
Morning, Mr. Chair and Senators. My name is Scott Hewitt. I represent the Texas Department of Public Safety here as a resource witness.
You heard Senator Hinojosa's question about a wheelie. Once somebody gets a car that's a ton or more airborne on the front, it can become a pretty bad hazard, true?
That is correct, yes, sir.
All right, and that's been something that's been occurring a little more frequently?
Yes, sir.
Okay, thank you.
Any other questions? Senator King.
Thank you. Although this takes a lot of fun out of someone getting their first vehicle.
We're having a laugh over here, sorry.
I'm sorry. But so the bill says that an operator of a vehicle may not intentionally or knowingly accelerate the vehicle in a manner that causes any tire of the vehicle to lose traction or to leave the surface of the highway. And if you do, it's a Class C misdemeanor. I understand the intent, but it sounds like if I'm just driving in the rain and I give the gas a little too much gas, instead of it being that I just hydroplaned a little bit, or my tire spun, or maybe even lost control and had an accident, that it would become a criminal offense instead of a traffic offense?
I think that was the point of introducing intentionally or knowingly into the statute. The intention of the action is to break traction as opposed to an unintentional break of the traction. So that's why those terms were introduced to the bill.
Yeah, well, and I understand what he's trying to do, and the author, and I appreciate that very much. I just, knowingly is probably what bothers me. It's almost impossible to hydroplane without intentionally having done something or knowingly having done something.
Need to drop the burnouts. I think it just, wheelies are really the problem. Once the car gets airborne on the front tire.
Yeah.
It's really motorcycles.
Well, yeah,
The scary part.
Motorcycles doing that continuously on major roads that I see now on highways.
Yeah.
But Senator King, if you want to take, one of that out, I agree. I'm just trying to get to the really egregious behavior. You're right. Somebody will hit the gas and they could do, on a corner, they could burn out the inside tire, not thinking that they're over accelerating, or if they found out a limit in the vehicle. But, so, if we want to drop one of those terms, but the wheelies, I've seen this enough to where once they get airborne like that, they lose control of the vehicle until they get the front tires back down.
Wheelie's bad.
Yeah, right.
Thank you.
But I'm happy to take a floor amendment to change that.
Senator Miles.
I'm assuming this has to do with all the problem we've had in Harris County the last couple of years.
No, actually,
Bel Air.
I mean, Westheimer is always a problem.
And Bel Air.
Yeah, in Bel Air because they're popping the car's front tires up and going for a period of time, and the motorcycles are really a problem even on the major interstates now. They're just pulling wheelies in between traffic and moving at speed. I don't know how you can do a wheelie at 40, 50 miles an hour, but they can. Okay.
Do it at 70.
Yeah, well, she just said 70. I mean, this is death-defying Evel Knievel stuff that's happening on the roads. Is that a good question? A good summary?
Yes, sir.
Thank you, Sergeant.
Senator King, you have any more?
No, that's fine. Thank you very much.
Thank you.
Thank you, Sergeant. Chair sees no one else for invited testimony. So invited testimony is now closed. Chair now opens up for public testimony. There's no one registered to testify publicly. Is there anyone here who wishes to testify on, for, or against Senate Bill 2017? Hearing none, the bill will be left pending. So Senator Bettencourt, you were going to do a committee substitute for Senator
Right.
Middleton.
I'm going to do that right now.
This is SB 476 by Middleton. Senator Bettencourt, you will be laying it out for as a matter of pending business. Chair lays out Senate Bill 476 and recognizes Senator Bettencourt. Whether the chair sends up committee substitute for Senate Bill 476, is there objection to the adoption of the committee substitute for Senate Bill 476? Hearing none, so ordered. Recognized Senator Bettencourt to explain the difference between committee substitute and bill is filed.
Thank you, Mr. Chairman. This is a committee substitute for Senate Bill 476, which addresses penalties for those who bypass interlocking restriction devices on vehicles. Per the comments by Senator Middleton, this committee substitute was at the suggestion of Senator Huffman, and it clarifies that it is an offense of the first-degree felony if the actor did not hold a valid driver's license because of a court order to suspend or revoke the driver's license. And with that,
Members, are there any
Move it on.
questions? If not, we'll hold the bill as pending. Thank
yeah,
you.
thank you. Nice to be back.
Senator King, were you going to do one for Senator Hughes?
Yes. I was just reading it for the first time myself.
Chair lays out Senate Bill 1659 and recognizes Senator King on behalf of Senator Hughes to explain the bill.
Thank you. Senate Bill 1659 addresses a loophole that allows law enforcement to bypass the Fourth Amendment by purchasing detailed geolocation data from private data brokers and trackers. These entities collect sensitive information from our smartphones and apps, enabling unchecked surveillance without the judicial oversight required for traditional methods like phone taps or GPS trackers. Senate Bill 1659 requires that governmental entities obtain a district judge-issued warrant backed by a probable cause to access location data purchased from data brokers or electronic trackers. This ensures that geolocational data receives the same scrutiny as direct surveillance, safeguarding the privacy of U.S. citizens. The bill defines location information broadly, covering data collected without consent, and sets rules for how long the prospective data warrants remain intact. The enforcement compliance, Senate Bill 1659, to enforce compliance, Senate Bill 1659 declares evidence from unauthorized searches inadmissible, requires notification of citizens affected by the violations, as well as the destruction of improperly obtained data, and there are resource witnesses available to answer the questions about the bills.
Thank you, members. Any questions? If not, the chair now opens up for invited testimony. There's no one registered for invited testimony. Invited testimony now closed. Chair now opens for public testimony. Chair calls W. Scott McCullough, Greg Nojheim, and Kevin Hale. W. Scott McCullough, Greg Dojheim, and Kevin Hale. We'll begin on my right. If you're set your name, who you represent, your position on the bill, and you have 2 minutes.
Hi, my name is Greg Nojheim. I'm with the Center for Democracy and Technology.
Could you move the microphone so we can hear what you have to say? Thank you.
My name is Greg Nojheim. I'm with the Center for Democracy and Technology. We're a nonprofit, nonpartisan organization located in Washington, D.C., and we deal with internet freedom issues. I've been working on these issues for almost 30 years, and I've seen Texas lead on many of them. For example, in 2021, Texas enacted a statute requiring warrants for the compelled disclosure of location information, which can reveal a person's pattern of worship, what doctors they see, with whom they meet, and other private facts. Today, with SB 1659, this body can take another step in ensuring that Texas law keeps up with technology advances. Those advances have resulted in the development of a market in which personal location information is bought and sold, with law enforcement sometimes on the receiving end. Under the current statute, a warrant is required when law enforcement compels, say, T-Mobile, which services this cell phone, to reveal my location here, to reveal that I drove over from Houston, to reveal that I flew down from Washington with my wife, and other information about my travel. That's what current law does. But if law enforcement wants to purchase that same information from a data broker, the warrant requirement doesn't apply. S-1659 would fill this gap. It would require law enforcement to obtain a warrant to search through location information purchased from a data broker. It would make it so law enforcement could not buy its way around the warrant requirement that this legislature adopted just 4 years ago. We urge you to report the bill out favorably. We also urge you to consider including narrow exceptions from the warrant requirement, such as for an emergency when there isn't time to get a warrant. We look forward to working with you on this legislation. Thank you.
Thank you for your testimony. Please proceed.
Thank you, Mr. Chairman. My name is W. Scott McCullough, testifying in favor of the bill. I've practiced telecommunications, internet, and privacy law for 10 years more than Greg over here has. We've had a good time together, but I'm here on behalf of Texas.net. We were one of the first internet service providers when the internet became publicly available in 1996. Still around, and we support the bill. 1659 is needed because, as Greg said, state and local government agencies are able to bypass the courts by buying location data from third parties instead of getting a warrant from like the cell phone company from which it was generated. This loophole lets law enforcement avoid judicial oversight through private data brokers. Police already need a warrant, as Greg said, to get the information directly from the phone company. This just gets at the people who are acting now as middlemen for the same stuff. The same rules should apply even if the data is bought from a third party. What does the bill do? It requires law enforcement to get a warrant before accessing location data from third-party data brokers. It protects Texans from government surveillance without consent or cause. It keeps private companies from becoming a backdoor to sensitive personal information. It extends Fourth Amendment protections to modern digital data markets. It ensures the courts, not private vendors, decide when the government can access your information. It doesn't stop investigations. It just keeps the courts in the process to safeguard rights. This bill brings consistency to legal standards and the evolution of how our digital technologies have gone over time, regardless of how it's obtained. This is a good bill. We ask that you favorably report it.
Thank you for your testimony.
Thank you. My name is Kevin Hale. I'm with the Libertarian Party of Texas, and I swear that I'm not trying to undermine Senator Hughes's conservative credentials, but we love this bill, and we think it's a strengthening of the Fourth Amendment, and we will say ditto to what has already been said, because when you read my writing, that's exactly what we said. Thank you.
Thank you for your testimony. Members, any questions? Thank you all for being here. Yes, Senator King.
I don't know who the right person is in But, and I guess I'm feeling kind of bad since I actually laid the bill out, but this is a first impression thing for me. So the general rule has always been if it's public data, law enforcement didn't have to go get a warrant to get it. And for better or worse, if I understand it, this is all public data right now that any of us could go out and buy from a broker. Is that right?
I wouldn't characterize it as being public data. This is information that somebody like a third-party broker has obtained from the original company that generated it. And the original companies that generate it generally keep it private, and they do not make it publicly available. There are various other arrangements where they have indeed sold it to these brokers, and that's where the problem arises. Right now, law enforcement has to go to the phone company to get this information. And we have the Fourth Amendment protections for it. But if the phone company then, for whatever reason, somehow transfers this information to a third-party broker, it loses its protection, and that's the problem we're trying to solve.
Okay, so I know the state, in fact, Senator Nichols had a bill 2 or 3 sessions back, and that where the state would sell driver's license data or something else, and in that contract would be very specific that it couldn't be released. It was used for whatever purposes. And then that purchaser, that vendor would then sell it to someone else. Anyway, by the time it worked through 3 or 4 people, there was no control over it, and it was out in the public. And so is that what you're saying is happening here? Okay. It still seems odd that law enforcement would not be able to get access to stuff that, for whatever reason, is public. It seems like maybe we're not turning the faucet off at the right place.
I don't know that I would characterize this as public information.
Okay.
Yes, it has been exchanged between 2 private parties. That doesn't necessarily make it public information.
So the phone company sells it to some marketing company that's going to use it for whatever purposes, or research or whatever, and then law enforcement goes and purchases it. But anybody could go and purchase it and law enforcement's just happened to saying, hey, if anybody can purchase it, let's go get it too, and we can find out where Phil was last night.
I don't think just anyone in the public can go to these third-party brokers and get this information.
Okay.
They have specific clientele to which they market this.
Okay.
Yeah, so usually what they'll do is they'll sell like a subscription to the database so that the law enforcement officer can buy the right to go into the database and look for location of a particular person. And they just enter the data and then they query it. I don't know if it's most or a lot of the brokers, they won't let non-law enforcement do that. They can let non-law enforcement do that. So it depends on the broker.
But isn't the reason they have to go get a search warrant to get information from the phone company is because the phone company just won't release it without a warrant? In other words, my understanding is, for better or worse, when I sign on to all these apps and everything else, I probably pretty well wave, and all of a sudden this is all public information, or it's all information that the company can do with whatever it wants.
If I may address that.
Yeah.
Actually, I was one of the folks who worked on the warrant for location information bill a couple of sessions ago. And the telephone companies were making available location information on less than a warrant. They could do it through an administrative subpoena or sometimes merely a letter. And the legislature decided that that was not sufficient protection for Texas citizens. They wanted to impose a warrant requirement instead. And again, this is just going to be a very similar thing. It's just elevating the law enforcement's obligation to go and get a judge's approval before they can access this private information.
Okay, thank you.
I have a couple, just to follow up, because I think we're sort of struggling over what's private now and what's not private. And so, that's an issue. But I guess my question is, if law enforcement can, legally get access to information that anyone in the public, you're saying not anyone in the public can do it, but I would like Are there any companies here that sell? I'd like more information. I mean, it's not that I doubt what you're saying. It's just I need harder examples of what we're talking
Are there any
about.
companies?
I mean, the first gentleman's kind of, you started this scenario if you flew here and you came from a different state, and that all that would be available to law enforcement if they went to these data processors. I mean, that's a lot of different sources. I mean, to your point, there's probably apps on your phone when you research a flight or you get off of a flight and you take an Uber and you stay at, you know, a Marriott or whatever. Maybe all that is obtainable. But that seems like that would be, unless there's some data collection company that's getting like all your travel. I don't know. It's complex. My concern is just treating law enforcement, putting, you know, handcuffs on them to obtain information that is available to the public. And to me, that there's a little different there. I don't know what the answer is. I wish Senator Hughes was here. We could ask him some questions.
Again, this isn't just public information that anyone can get. There are contractual non-disclosure agreements involved. It is simply that law enforcement can buy the subscription.
Yeah, and I haven't read the bill. It's a very long bill. I think it's just, I just saw it now. You know, maybe there's some descriptive language in the bill that describes these contractual centers, or, you know, the contracts. You know, so maybe if it was law enforcement was entering into contracts with certain companies, that if it got to that level, but I wouldn't want to tie the hands of law enforcement to do, you know, just kind of the old-fashioned investigation, and now they're just using the more tools that are more, you know, available in modern times. But there's probably a very fine balance there. I don't know if the bill gets us.
Location information is so personally revealing. These data brokers do collect a lot of information about us.
I pretty much believe they know where we are all the time. Yeah, I mean,
And
you know,
you
start talking about wanting like something, you know, buy something, and suddenly that ad shows up on your phone. I mean, I understand what you're saying, but
we just believe that it's so personally revealing, in particular, in contrast to some of the other information they may have, that it deserves this higher level of protection, judicial oversight before the government gets access to it.
Can I just add an example? Add an example. You wouldn't want to have a world where we always assume that the law enforcement is on the same plane as everybody else. And the reason I say that is law enforcement has powers to arrest. And it's different if a neighbor finds out where you've been over a long period of time because they follow you around.
I don't know. We might rather law enforcement know. Never know. I mean, I'm not arguing with you. I understand what you're saying.
Gotcha.
It's just there's a fine line. I think that we just need to make sure. I agree with you. If it's invasive, yes, it needs to be under control. But, okay, thank you.
Thank you all for your testimony.
Thank you.
I see no one else registered for public testimony. Is there anyone wish to testify on, for, or against Senate Bill 1659? Hearing none, public testimony is closed, and we will leave this bill pending. Chair lays out House Bill 353 and recognizes the Senate sponsor, Senator Hagenbu, to explain the bill.
Thank you, Mr. Chairman. Thank you for posting this late. I appreciate that, the opportunity to present this bill. Members, we recently passed this bill as SB through this committee 1602. The House bill came through more quickly, so we're moving the House bill forward, HB 353. We discussed this bill previously. It's about daycare locations and loiterers who are abusing the fact that we do not have any statutory protection to keep them away from the schools. HB 353 will help the safety concerns for children, staff, and visitors of schools and daycares, as well as provide law enforcement clear authority to act when individuals pose a risk or harm or repeatedly behave inappropriately near these institutions. It's supported by numerous law enforcement groups, including CLEAT, TMPA, and TCOL. The only difference in this bill versus SB 1602 that passed this committee recently is that the restricted distance is now 250 feet in this bill versus 500. I appreciate the chairman and the committee's consideration of this important bill. Happy to answer any questions. Thank you.
Any questions, members? If not, invited testimony is now open. There's no one registered to testify in invited testimony. Invited testimony now closed. Now open for public testimony. I see no one registered for public testimony on this bill, so anyone here present wish to testify on, for, or against House Bill 353? Hearing none, public testimony is closed. We'll leave the bill pending the vote.
Thank you.
Senator Huffman? Can you,
Yes.
for me, and I think it's the last one.
Okay, what is?
Oh, what's this in? 3248.
Okay, Chair lays out House Bill 3248, was sponsored by Senator Flores. Senator Flores, Chairman Flores, you're recognized.
Thank you, Madam Chair and members. So defense-based development authorities are charged with redeveloping former military bases into sites for aerospace, defense contracting, cybersecurity, and commercial innovation. As hubs for operations critical to national security and economic growth, these defense-based developments lack the explicit statutory authority to employ and commission peace officers, forcing their reliance on local enforcement. House Bill 3248 addresses this jurisdictional gap and ensures the safeguarding of critical infrastructure, research and development, and this bill grants these facilities the ability to employ and commission peace officers. And that is the bill.
All right, do we have any questions of Senator Flores? I don't see any questions. Okay, so we will now open invited testimony, and we will call up Juan Antonio Flores. Mr. Flores?
Madam Chair, Chairman Flores, members of the committee, thank you for this invitation to testimony, to testify today on House Bill 3248. I represent Port San Antonio. My name is Juan Antonio Flores, as stated, and I come before you to respectfully request the legislature expand our authority in order to commission peace officers. While we are no longer a active military installation at the former Kelly Air Force Base, we have a 1,900-acre real estate asset, and our business strategy for redevelopment of this platform has been to grow as a innovation and technology platform in support of the defense industrial base. And Chairman Flores, as you know, given that you used to represent our Port San Antonio, we've done this with great success. Today we have over 80 companies, enterprises, both public and private, employing over 18,000 workers in mostly the defense and aerospace and cybersecurity sectors. As we grow this vision and strategy and seek to double the density of our workforce over the next decade, we do believe it imperative to have, as other special purpose districts do throughout the state, the authority to commission our own officers. So we thank you for your consideration. I'm happy to answer any questions.
All right, do we have any questions, Mr. Flores? I don't, Ms., do you have a question? You know, your light's on. All right. No questions. Thank you very much for being here, okay?
Thank you all.
Your excuse. All right, that closes invited testimony. I now open public testimony for House Bill 3248. Do we have any cards? We don't have any cards, so is there anyone who wants to testify on for or against House Bill 3248? No one's responding, so we will close public testimony. Do you want to leave that pending or go ahead and vote?
We're gonna
Just
do
vote.
it pending, and then we're gonna vote everything out.
Okey-dokey. Yep.
Thank you.
That's going to be another.
Here we go. Keep track. Members, thank y'all for being here, and thank you for your patience. So we're going to vote this slate of bills out as you see fit. Yes. Yeah, I saw that.
Yeah,
we're not gonna vote that one out. Yes. Yes, ma'am. So we'll begin with House Bill 1, Chair calls up House Bill 166. So the chair moves that House 166 be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenboom. 6 ayes, no nays.
There be 6 ayes, 0 nays. House Bill 166 will be reported to the full Senate with a favorable recommendation. Chair lays out The chair lays out House Bill 353. The chair moves that House Bill 353 be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu. 6 ayes, no nays.
There be 6 ayes, 0 nays. House Bill 353 will be reported to the full Senate with a favorable recommendation. It's not eligible. Chair moves that House Bill 2000 be reported to the full Senate with a recommendation to do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu. 6 ayes, no nays.
Be 6 ayes, 0 nays. House Bill 2000 be reported to the full Senate with a favorable recommendation. Chair moves that House Bill 2756 be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu. 6 ayes, no nays.
6 ayes, 0 nays. House Bill 2756 will be reported to the full Senate with a favorable recommendation. Senator King, you recommend that House Bill 2756 be recommended for local and uncontested. Is there any objection? Hearing none, so ordered. Senator Huffman, I don't think I can do my own.
Is out House Bill 32-8, Senator King moves that House Bill 32 with a has to be printed. Clerk, call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu. 6 ayes, no nays.
6 ayes, no nays. House Bill 32-8 will be moves that certified to local and uncontested calendar without objection. So
Thank you. Chair lays out House Bill 3513, and I'm reading the wrong place. Chair moves that House Bill 3513 be reported to the full Senate with a recommendation that do pass favorably be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles,
Aye.
Senator King, Senator Hagenbu. 6 ayes, no nays.
There be 6 ayes, 0 nays. House Bill 3513 will be reported to the full Senate with a favorable recommendation. Senator Hagenbuth recommends that House Bill 3513 be recommended for local and uncontested calendar. Is there any objection? Hearing none, so ordered. Chair moves that Senate Bill 1730 be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll. 1730.
Yeah, okay. Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu. 6 ayes, no nays.
There be 6 ayes, 0 nays. Senate Bill 1730 will be reported to the full Senate with a favorable recommendation. Chair moves that Senate Bill 1778 be reported to the full Senate with a recommendation that do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu. 6 ayes, no nays.
There be 6 ayes, 0 nays. Senate Bill 1778 will be reported to the full Senate with a favorable recommendation. Senator Hinojosa recommends that Senate Bill 1778 be recommended for the local and uncontested calendar. Any objection? Hearing none, so ordered. Chair moves that Senate Bill 1790 be reported to the full Senate with a recommendation that it do pass favorably. And we'll hold that one as pending. So she wants to leave that one pending? All right.
Which one is that?
1790. We're leaving pending. And 1848. This is also pending.
Yeah, that's move for the House bill. Chair moves that Senate Bill 2017 be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker. Senator Hinojosa. Senator Huffman. Senator Miles. Senator King. Senator Hagenbu. 6 ayes, no nays.
There be 6 ayes, 0 nays. Senate Bill 2017 will be reported to the full Senate with a favorable recommendation.
Are we not?
Oh, yes. Chair moves that Senate Bill 2105 does not pass, but that the committee substitute for Senate Bill 2105 adopted in lieu thereof be reported to the full Senate with a recommendation it do pass favorably and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker. Senator Hinojosa. Senator Huffman. Senator Miles. Senator King. Senator Hagenbu. 6 ayes, no nays.
There be 6 ayes, 0 nays. The committee substitute for Senate Bill 2105 will be reported to the full Senate with a favorable recommendation. Senator Hinojosa recommends the committee substitute for Senate Bill 2105 be recommended for local and uncontested calendar. Any objection? Hearing none, so granted. $27.94.
Yes.
Chair moves that Senate Bill 2794 be reported to the full Senate with a recommendation that do pass favorably and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker. Senator Hinojosa. Senator Huffman. Senator Miles. Senator King. Senator Hagenbu. 6 ayes, no nays.
There be 6 ayes, 0 nays. Senate Bill 2794 will be reported to the full Senate with a favorable recommendation. This one next.
No, 476.
Chair moves that Senate Bill 476 do not pass, but that the committee substitute for Senate Bill 476 adopted in lieu thereof be reported to the full Senate with a recommendation do pass favorably and be printed. The clerk will call the roll.
Chairman, is that, excuse me.
476 by Middleton? It had the committee substitute that changed it to a first degree.
Was it Middleton?
Yes.
That's the one who they pretty much expended on the life without parole issue on DWIs?
They took it to this committee substitute was brought it to a first degree felony.
Yeah.
From the life without parole. It's still in there? Yeah.
I don't know. I thought it was going to be like, I didn't know it was like.
Yeah, it is.
Well,
It's still life.
Life without parole.
So do we wish to? Nah.
It still gives life without parole, actually expended.
They did not.
Yeah. Well, yeah, but now it's expanded to also include somebody driving without a license. It's still life without parole. There was no change to a first-degree felony. Yeah. I'm gonna know this stuff. Yeah.
So we'll leave this bill as, continue as pending business until we get more clarification from the office. So now is another issue of pending business. The chair moves that Senate Bill 2611 do not pass, but that the committee substitute for Senate Bill 2611 adopted in lieu thereof be reported to the full Senate with a recommendation do pass favorably and be printed. The clerk will call the roll. This is
Sure.
Senator West's bill.
Chair Flores,
Yep. Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman,
Aye.
Senator Miles,
Aye.
Senator King,
Yes.
Senator Hagenbu.
Aye.
Okay, 6 ayes, no nays.
There be 6 ayes and 0 nays. Committee substitute for Senate Bill 2611 will be reported to the full Senate with a favorable recommendation.
I do have a committee substitute. Didn't think I did. And the committee substitute, the original bill was the juvenile board goes from 9 to 5. The substitute goes from 9 to 7.
So the chair recognizes Senator Campbell for Senate Bill 1790 with a committee substitute.
Yes, the original bill was juvenile board that goes from 9 to 5. The committee sub goes from 9 to 7.
Donna,
I was, well,
Senator Campbell, I could have explained, you didn't have to run down here. I think I probably could have explained that.
well,
for
you could have, but I felt like I had to face the music because I said
You said it was real short and sweet the first
it was
time.
short and sweet, but you have to see it 2 times.
I know why, because DA Tharp is here and you wanted to.
Well, I really wanted to do it perfect,
Yeah, I know.
but my staff, well, I'm not blaming them, but we thought that it was actually just rolled in. We didn't have to have a sub, but we have a sub, and I sure would appreciate 100% unanimous vote.
What?
Feels in good shape.
Is there any objection to the adoption of the committee substitute? Hearing none, that is adopted.
Thank you, members, very much.
So the chair moves that Senate Bill 1790 do not pass with the committee substitute for Senate Bill 1790 adopted in lieu thereof be reported to the full Senate with a recommendation do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu. 6 ayes, no nays.
There be 6 ayes, 0 nays. The committee substitute for Senate Bill 1790 will be reported to the full Senate with a favorable recommendation. Senator King recommends a committee substitute for Senate Bill 1790 be recommended for local and uncontested. Is there any objection? Hearing none, so ordered.
Thank you.
Members, thank you all very much. This concludes today's hearing, and we'll go to the floor, and we'll remain subject to the call of the chair.